Good afternoon, everyone. Thank you for joining. We are going to go ahead and get started right away and be conscious of everyone's time. Thank you for continuing this discussion of the Federal Trade Commission's evolving enforcement strategy with respect to advertising practices in the automotive industry. I'm Tyler Requette, President of Mosaic Compliance Services, and I'll be moderating this discussion. But before we get underway, a bit of housekeeping. The content of this webinar is intended for discussion and educational purposes only and is not intended to constitute legal advice or the practice of law. The stakes are high, so if you need legal advice on your actual advertising practices, please seek local competent counsel. This webinar is being recorded and will be made available through Mosaic, NCC, and ProMax's websites in short order. In addition, we will send a link to the recording to everyone who registered for this webinar. And finally, we welcome your questions. We're excited to answer them. Please use the chat function or the Q&A function within Microsoft Teams, and I'll present them to our panel as appropriate once we finish our presentation. It's my pleasure to introduce you to our wonderful panel. First, we have Jim Ganther. He's an attorney specializing in automotive compliance issues and is the founder and CEO of Mosaic Compliance Services. We have Gil Vanover III, who's the president of Mosaic Audit Services and a longtime industry veteran with heavy emphasis on variable ops, auditing, and consulting. We have Jim Dietrich, the senior vice president of product. He leads credit and compliance product business at NCC and brings over 20 years of experience in data, risk, and compliance across multiple industries. And finally, we have Greg Becker, the Chief Product Officer at ProMax, who has over a decade of experience in retail automotive. Welcome, ladies and gentlemen, and thank you for joining us today. Let's start with Jim Ganther.
Yes.
Jim, in your opinion, what's the biggest takeaway from the FTC today?
To me, the biggest takeaway was what didn't happen. I think everybody who attended the NADA FTC webinar that preceded this one was expecting answers, literally going there to get answers. We all had questions, and the FTC affirmatively stated, we're not answering any questions. So that was a disappointment. And because we didn't get some of those questions answered, we've got to be very conservative in the advice that we give or, the discussions that we have. So that was the biggest one, is what didn't happen. But to me, the biggest takeaway from what did happen was the FTC unambiguously doubled down on the contents of their, March 13th letter. And of all the bullet points that were addressed, there were 6 bullet points in the letter. The one that was stressed the most by almost an infinite margin was number 1, advertising a price that does not reflect all required fees. A little bit less was the second bullet point because it had an interesting anecdote to back it up. And that is, thou shalt not advertise a price that reflects rebates or discounts not available to all consumers. And Helen Clark, the FTC representative, gave the example of a dealership that deducted 3 mutually exclusive rebates from the advertised price. To get the price that was advertised, you had to simultaneously be active duty military, a first responder, and a firefighter. Well, that doesn't happen. And they were set straight. So those are the 2 big takeaways, and I could get as granular as you would like me to get, Tyler.
Yeah, Jim, I would say to be respectful of everyone's time, but still provide some good information, go into a little bit more detail about maybe the questions that were raised by the FTC and some of the issues that were not answered, but are going to be the most important things to get fleshed out in the coming weeks.
The one question that was hammered on by Brian from the FTC was the concept of preemption. What do you do when you have a state law that says you may not include dealer fee, doc fee in the advertised price? And there are at least 3 states that have that position, and they are Oregon, Washington, and Connecticut. And the logic for that is kind of clear. If the intention is to allow consumers to comparison shop, to compare prices, one of the elements you want to know going into a dealership is how much is their dealer fee. So they're not crazy laws, but they directly conflict with this federal law. And when that happens, the Supremacy Clause of the United States Constitution squeezes out something that we call the Preemption Doctrine. If federal law and state law on the same subject matter conflict, federal law wins. Well, what are you going to do if you're in Oregon, Washington, or Connecticut, and your state law says you have to separate out dealer fee? Which law do you want to violate? So I don't know how that is going to be resolved. Just because the FTC didn't answer any questions today doesn't mean they won't in the future. And this is a very, very big one. I am predicting here that when the FTC starts enforcing these guidelines, enforcing their interpretation of the advertising requirements derived from Section 5 of the FTC Act, you're not going to see enforcement action initially in Oregon, Connecticut, or Washington. That's just my guess. I would bet that if they're going to do heavy enforcement activity, they would go to a state like Florida that has an affirmative law right now saying you may not exclude dealer fee, doc fee from your advertised price. That is where their odds of prevailing would be the greatest. And that's what I would predict.
Fascinating. Thanks, Jim. Yeah, we're going to have, I'm sure, questions about this as we move forward, but already we have dealers separated into buckets by state, right? We have the 3 states where you are required to exclude the doc fee from your advertised price. We have 20 states as NADA referenced that allow you to exclude doc fee from your advertised price. And then we have a number of states like Florida, for instance, where you are required to include doc fee in your advertised price. So
one other thing I'd like to stress before we move on is the FTC stressed at the very beginning that we're only talking about how we interpret advertising under Section 5 of the FTC Act. The FTC rep heavily stressed, Helen Clark stressed, that there is still the Truth in Lending Act, the Equal Credit Opportunity Act, the advertising requirements from Reg Z, from Reg M. All of these are still in force, and they're all going to be enforced. Just because the FTC is stressing this particular unfair and deceptive advertising issue doesn't mean they're going to ignore all of the others. So if you have an advertising practice where you deduct dealer fee from your advertised price, and your ads have trigger terms under Regulation Z or Regulation M without the full disclosures in the credit or leasing arena, you're going to get hit for all violations, not just the Section 5 violations. Don't forget that. There's a whole body of law out there that you may not ignore.
Well, thank you, Jim, for the legal perspective. Shifting over to an operational perspective, let's turn first to Jim Dietrich of NCC. Jim, can you tell us briefly what NCC does and how it fosters dealership compliance generally, both related to what's going on and just, like I said, generally how NCC helps dealers with compliance?
Yeah, sure, Tyler. NCC and ProMax help dealers bring structure and consistency to how deals are worked from start to finish. And so ProMax sits on the front end as the CRM and desking platform. So that's where we get into the pricing and quoting that we're going to talk about today, while NCC provides the credit and compliance backbone, the bureaus, identity tools, and required compliance steps all into one guided process. And so together, that creates a unified workflow where every step can happen in the right order and it's properly documented. And that's where the compliance comes in. There's a lot of requirements in a deal, and they're easy to miss when you rely on manual processes or memory. And the FTC enforcement, as Jim had mentioned, is starting with advertising, but with the potential to expand, and Helen listed all those regulations. FCRA was at the top of the list. And so for dealers, this really is the moment to step back and look at how a deal is actually executed end to end in the dealership. And that's where we come in, helping create that controlled workflow that ensures things are done the right way every time and it's documented.
Yeah, absolutely. I mean, I think a theme of this webinar that you're about to hear for the next 50 minutes is that dealers need to come into compliance very quickly with what the FTC is hyper focused on. But what they're focused on is already established law. And to me, that signals that they need to come into compliance with all established law relatively quickly to put themselves in the most advantageous position. Thanks, Jim. So then I'm going to shift over to Greg. And I want to focus on the payment quoting process and how dealers can ensure that the price that drives the monthly payment is not higher than the advertised price, and making sure that that price includes all the non-governmental fees.
Thanks, Tyler. I think, the biggest takeaway I think from that is, and I think everybody's kind of saying it, you have to make sure that you're dotting your I's and crossing your T's and doing the right things as far as the way that you advertise and then the way that you respond to the information and the lead when it comes into the system. From a desking perspective, I think there's a right way and a wrong way to present numbers to a customer. And I think based off of individual states and the way that they look at it, I can give you an example of the right way or the wrong way, right? So for example, on this particular quote here, we see that we have a selling price and we have gap fees, and we have where gap doesn't necessarily fall in line because the equity of the customer is significantly less. And so we wouldn't want to have gap on this deal. In some states, this would be out of compliance just by having gap on it. And you have your title and your reg and doc fees, right, that have been pulled out that are not included in the selling price. And what I heard from Helen was that she spent a lot of time talking about the way that the prices are displayed, right? Clear and conspicuous, font size, coloring, the way that the information is placed in someone. And so when the consumer sees that out on a third-party website or lead generation, or even on the dealer's website, the information that the consumer sees that allows for them to engage with the dealership versus what happens when they come into the dealership and they get penciled the first deal is where the deceptive falls, right? So the customer sees it's X dollars with X fees. And then when I get there and you put a deal in front of me, it's completely different. And so what the takeaway from that is that your deals should look like this, right? Where your all of your fees, all of your doc fee, provided that you're not in one of those three states, right? Let's look at how we say this, right? Is that everything is inclusive in the price that the customer is paying. And so it is clearly defined that this is the total selling price of the vehicle, that there are no additional added or exclusionary fees. If you need to break out the doc fee, right, and have it as a line item because it is a printable line item on the contracts that go out, your selling price has to be inclusive of that, and then you break it out and your total amount financed is inclusive of all of those fees. So there's the left methodology where I have my fees are broken out and totally separate and added on to the selling price, and the right methodology where everything is inclusive of a total advertised selling price to include the document fees, and anything that is assessed in that fee, and the customer has a clear and concise understanding of what it is that they're purchasing. I think that also goes to how do you set up your systems, right? And the challenges that dealers are going to have with varying degrees of software all communicating to each other.
Yeah, absolutely, Greg. And I think that kind of leads to the next question of what's the mechanics of making sure this happens, and not just happens once, but making sure that it happens every time for a dealer.
So a dealer's going to be challenged to sit down and do an assessment. Who manages my inventory? New car inventory comes out of the DMS, used car inventory comes out of a third-party provider, potentially where I'm doing market pricing and appraising. They're both being syndicated out to yet another provider, which is a website provider who is controlling the pricing and the visualization of how it looks online, which also led me to some of the things that they were saying is it's the dealer's responsibility to hold the accountable that the pricing is being displayed appropriately. So you've got potentially a DMS, potentially another software provider where you're managing your inventory, then going to a third-party lead provider that is your website. But then also, there's hundreds and hundreds and hundreds of lead generation tools out there where the inventory is syndicated that are all different. So a single source of truth, dealers are going to have to assess, how is my inventory managed from a pricing perspective? Am I inclusive or exclusive of fees? And, she hit hard on rebate stacking, right? That example that she provided could also apply to a first-time buyer, off-lease, recent customer returning with a certain model, right? There's all different incentives that come from the manufacturer. So, having kind of the generic rebate that applies to everybody be inclusive in the price, and then stating that there are other rebates that are available if you qualify, is going to be very important. Once that lead is generated from said third party into a CRM, the dealer now is faced with the next level of challenge, which is my lead information came in. I've got a vehicle of interest that was generated from an online provider with a price. Now I have to move that through my system to a desking tool. So is that desking tool inclusive inside of my CRM, or is it external? Is it back to my DMS? So you have more moving parts of where this data is going through filtration of both what data is shared with external third parties, and is that system capable of being configured to account for the settings that you need to adjust the way that you present numbers. And so when we think about that and we talk about how fees are assigned inside of a system, how rules of engagement are applied, how PAC is applied, where your fees are all applied at the same level on every vehicle as it's syndicated out. And when it comes back in, that's connected to your desking tool, which is pulling in that piece of inventory that has the price on there. You could have some delay on some third-party websites from a syndicator as far as whether or not they get a feed overnight, whether or not they get a feed hourly or in real time. Those are some challenges as far as how the data moves, but having a system that's flexible enough to understand how I handle my fees, how those are applied to a deal, and how they are presented to a consumer, flexibility and is going to be really important to allow the dealer to make sure that they're in compliance.
Flexibility seems like it's going to be really important. Ability to change quickly, I think, too, is going to be important as the FTC and NADA continue their discourse and we continue to get more clarity on what exactly the FTC is looking at and when.
Absolutely. So as much as the dealers are feeling the ambiguity of which direction they're supposed to go, a lot of integrated partners are going to feel that as well. We integrate with over 1,000 different providers at some point during the deal, and we're going to have to review how that data moves for every single one of them.
Absolutely. And I think all vendors are going to need to keep their ear really close to the ground on this. We did have questions from Brian to the FTC about dealers maybe not being in control of a lot of their data and how that's listed on either their websites or through the lead generation companies. And if I was a dealer, I wouldn't want to be in a position where I wasn't in control of my pricing data. And I would certainly be looking for vendors that could give me the utmost confidence that when I need something to change, it's going to change quickly. I don't want to be out of compliance because of what one of my paid vendors is doing.
Absolutely. And for anybody that was on the prior webinar, she gave some nice examples of the actual ads that caused the issues. Mm-hmm. As a dealer, step one, if that's how your ads look, you need to make some changes pretty quickly.
Absolutely. Thank you, Greg. Gil, you've been focused on the dealership audit process for over 25 years. Sorry to age you. What role does audit play in confirming dealership compliance with the FTC's advertising standards?
Gil, are you out there?
Gil, I think you're on mute.
No, I'm not.
Welcome.
Thanks. What I'm amazed about is the sudden interest in automated and AI-enabled ad review systems. We have one, and so do our competitors. So finding such a tool is not going to be hard to do at all. It's just ironic, I think, that Friday the 13th, scariest day of the year, is when the FTC chose to put out the press release. And before that, there wasn't any interest in an AI tool to vet your advertising. Now that interest is, quite frankly, off the charts. I'm sure most of these systems work the same way. You insert the URL, you insert the spot from social media, a TV ad, print ad, whatever medium that you're using to advertise. And the system will review the ad against the FTC standards and NADA's interpretation from a few years ago. It then will provide and generate a written report with an action plan as to how to correct it to bring your ads into compliance.
Yeah. How can a live human help with these things?
Well, there's a new word emerging around the whole topic of AI called slop. And the advertisers are really paying attention to it. Some places are even advertised that these are not AI generated ads because the consumers are starting to become a little leery about the output of AI. AI it can be a fabulous tool when it's used to segregate data like we're talking about here and provide definitive reports. When we do our human audits, we're going to add an AI review of the dealer's website as part of our audits. We're going to score it, and we score every potential violation that we come across during our deal file review, but we'll also score that and provide a dealer with a written report from our system showing what they need to do to bring themselves up to speed. We also have an AI driven audit software that we're going to add that same advertising review tool into.
Yeah, the AI, like you said, AI is really great for a lot of tasks and still has a long way to go on some of the more nuanced things. It's great at crunching data, like we've found with our solution, that it's great at evaluating hundreds and hundreds of VDPs much quicker than a human could. But a lot of the nuance on those VDPs, while it gets flagged, it still needs to be reviewed by a human because, what was that other word we heard a lot on that webinar today? It was the most prominent price, the most prominent price. It seems like that's going to be a theme moving forward. And there's a little bit of up for interpretation involved in determining what that most prominent price is on a lot of these pages. So yeah, the AI audit capabilities are great, but I think what's another term that Jim and I constantly hear is a human in the loop, right? You want to have a human in the loop of a lot of these systems, and I think that's probably the sweet spot for coming into compliance. Gil, anything else?
I would think, Tyler, let me interject here. I would think that if the FTC received a complaint, they decided to investigate a dealer, and they get the advertised price, they're going to compare that to the transaction. And that's what a human has to be able to do with any ad review process, because initially we would just be vetting the ad to make sure it's right. The second question becomes, is that what the consumer paid for it?
Right. If you were a dealer, how long would you be keeping copies of your ads?
Statute of limitations perhaps is one answer. I think the California CARS rule that'll be in place in October has a statute of limitation there of 2 years. And it's I would go with at least 2 years or perhaps a statute of limitation for the FTC or your state, whichever is longer.
If we could open up, thank you, Gil. and everyone else feel free to jump in as well, but it seems to me that it might be a best practice for dealers moving forward to be able to trace each transaction back to a specific ad so that we can compare that advertised price to the price that the customer actually paid. How many dealers are doing something like that now? And of course, we talk about each deal, but the ads come from different places. So how do, digital leads, e-leads come in? How do we track those versus how do we track a phone call or someone who just walks in and says that I saw a price while I was watching football on Sunday?
I think most dealers that leverage software from a CRM perspective have a lead management system that when the lead is submitted from the third party or their own website, that information is captured to include the vehicle of interest, the lead source, and defining pieces of information about that vehicle and other comments that come through. That over time has amended, but it's called ADF. It's automotive digital format. It's the way with which data is consumed from third-party lead providers. For instance, in our platform, and most CRMs work the same way, we consume a date and timestamp with that data exposed in a raw data format, and we convert it to a more legible version for the sales rep to be able to read. Phone ups, a little bit of human intervention there, right? So you log a phone call, you're going to associate a vehicle of interest with it, and hopefully the proper sourcing. Again, you insert human. And from a walk-in perspective, I think what's going to happen is that the contentiousness and the self-reporting, and you heard the FTC state that dealers were reporting dealers, is that I walk in and ask about that vehicle, and you quote me that vehicle, but you have it advertised online for a different price. And so I think ultimately there's no right way to do the wrong thing here. This is most dealers do the right thing. Most dealers advertise right. They honor what they put out. They do those things. If there are a few bad apples, that's what happens when something like this goes on. But dealers are going to have to make sure, maybe inserting a policy and a compliance workflow product that allows for them to validate the selling price against the lead price. If there's a tool available, NCC offers a tool that does a compliance workflow that mandatorily makes them check steps before they can proceed to the next step. So we may have to insert some self-checking mechanisms that the dealership staff have to validate that they've checked against that selling price. But there are going to be areas of opportunity for error that we need to plug.
Let me jump in on one thought on this idea of, how do you retain evidence of the advertised price? Keeping a photographic record of a dynamic website seems to me to be a pretty substantial administrative burden and probably costly. But as an attorney, business litigator, we manufacture admissible evidence. And what I think should be an acceptable record retention is if you have a tool like ProMax that date stamp, timestamps every change, and you control that, not the dealer. If you 2 years from now can say, this was the advertised price and we were the source of truth, it was syndicated from us, I don't think you're going to have to prove, here's the picture, here's the vehicle description page that we saved from 2 years ago. Here is our advertised price. Here's every time it may have changed. Here's what's in it. If I can put that in front of a judge, that should be admissible evidence. The FTC answered no questions today, and that's a really good question. But if I were taking it to court, I would argue that you have a third party who's tracking this. You cannot prove a breakdown in the software or in the process, and the process ensures appropriate pricing and advertising 100% of the time. I think that should be good enough. I'd take that to court.
And we do, so just as much as we track permissionable purpose, when someone
Right.
submits a credit application that they've authorized, we treat inventory the same way. So if we manage inventory and syndicate that inventory, we date and type stamp an audit log of every change that's associated, whether it be miles or options or features or book values or pricing, and when it, and date and time stamp when it has been syndicated, and produce a printable log on every piece of inventory, new and pre-owned.
Hey, Tyler, would it be okay if I focused on the two cases that Helen Clark mentioned and discussed at length?
Yeah, absolutely. I think that would be helpful for the audience.
Okay. Helen Clark from the FTC highlighted two recent cases that were both initiated in 2024, and one of which is resolved, one of which is going to trial. And they were the Manchester City Nissan case. That one is going to trial. And the Lindsay Auto Group case, that one has been settled by consent order in the very, very recent past. I've got both of those cases up on this screen, both of those complaints. And I want to make a couple of comments because it wasn't an accident that she focused on these two cases. She's telling the dealership community, read these cases. What happened here can happen to you. And the first thing you notice from both of those cases on the cover page is both are against dealers, dealerships, and specific individuals. The Manchester City Nissan case, 1, 2, 3, 4, 5, 6, 7, 8 seven. One's an alias. 7 individual defendants. And when you go to trial, you don't know what the verdict form is going to look like. Those 7 individuals could each be hit for $216 million. Why did I pick that number out of thin air? Because there is an individual defendant in Chicago right now, Jimmy Duvas, who is still in an FTC and Illinois case, and they're trying to hang him individually for $216 million. These cases are all connected, they're interrelated. The sins in that Leader Automotive Group case are the sins that we see in these other two complaints, and they're hitting an individual human for more money than I think he will ever earn. Getting back to the two cases, they both have individual liability at stake. They both have screen captures of web pages as exhibits, as examples within the complaint. And I'm looking at one right now, and wow, this looks very much like every other ad I have ever seen. In other words, what we're seeing happen is that these cases are somewhat representative, that in the Lindsay case, they're being sued for doing that which I would say a majority of their competitors in that market are also doing. So we're all on notice. The Lindsay case, as mentioned, settled very recently for $78.1 million. That's a lot of money. $75 million is dedicated for refunds. $3.1 million is a penalty that's going to the state of Maryland, not to the Federal Trade Commission. Why is that important? Brian Bennett mentioned that 5 years ago, almost to the day, it was 5 years ago this month, we had the AMG Capital Management case that was heard by the Supreme Court, and in a 9-0 ruling, the Supreme Court agreed that the Federal Trade Commission does not have the legal authority to assess monetary fines until a defendant has violated a consent decree. So they can't go straight to the $78.1 million fine. In order to do that, they have to go in with either the state attorney general or the Federal Department of Justice. And in the Lindsay case, all of the fine that wasn't committed to refunds, all of the penalty went to the state of Maryland, not to the Federal Trade Commission. And reading between the lines, the Federal Trade Commission is saying, state attorneys general, we've got a great way for you to meet your budget. We have a great way for you to make money. We'll do the investigation. We will draft the complaint. We will generate the discovery. We will argue the case. All you have to do is assign an appearing attorney, put your name on the paperwork, and collect a big paycheck, and we'll do the work. That should be concerning to me if I were a car dealer. And with that, I'll stop talking about those cases. Perhaps we can make them available to the attendees, because trust me, there's not a dull word in these.
Yeah, I'll get with our team. We'll try to get the links for those cases out with the follow-up email and recording of this webinar. Sure. We'll also have them all available on a landing page, all about this recent FTC enforcement action on the Mosaic website. So Jim, just so I hear you correctly on that last point, if I'm an AG in, say, Florida, I can look at what just happened with the FTC and say, if the FTC is partnering up with state attorneys generals to put their name on a case to assess monetary fines and giving the state all of the proceeds, I can make a quick few $1,000,000 and not do a whole lot of work.
I am being a little bit cynical in that analysis. I suspect the state attorneys general offices will be doing real work.
Sure.
I'm not here to denigrate their efforts, but I'm not sure that they have to. And at the end of the day, if you're the dealer, it doesn't matter whose bullet hits you. You're still going to be dead.
So on that point, we have a great panel here. What should dealers do today?
Let me throw this one out, and then I promise I'll shut up. I would immediately start complying with what the FTC said in their March 13th letter. I would do it immediately. I would make sure my ads are up to snuff. I would do a complete review of our advertising to see, are we also complying with the Fair Credit Reporting? Are we also following Reg Z, Reg M, and so on? I would do a audit of our process and make sure we're doing everything we can to follow the law. That may put you at a competitive disadvantage in the near term. You may be able to feature the fact that you're being a law-abiding dealer in the ads themselves. Call out your competitors. And it's been mentioned, we have heard from dealers who said, I'm going to comply and I'm going to rat out my competitors who aren't complying. I would be concerned about that. Maybe I should ask the ProMax NCC guys about what would you do from a process and software standpoint?
Yeah, I would just add, first of all, Jim, agree with what you said. Make sure you're complying. But secondly, the software can help ensure that you're documenting that you're complying, right? And I think there's so much technology available today. We have it, others have it, that there's really no reason why today you can't, in a very easy way, ensure that the platform you have in place has a controlled workflow that's defined by you, that documents every step in the journey that you say you're doing. I don't know, Greg, what you'd add on to that?
Yeah, I concur with both of those. I think, where do dealers start today? Take a deep breath. Lots of change coming, right? Part of this is don't be overreactionary, but be persistent and provide action, right? For those of you that have not audited, or many of you, if you're general managers or dealer principals on this call, you're probably not doing the day-to-day work. So inspect what you expect, right? Hold accountability. What is the culture of your organization and how do you represent and present yourself? Go shop your website as a consumer. If you see ambiguity, fix it. Be transparent. Document what you're doing. Start investigating your processes. Where is your data at? Who's in control of doing it? What are the timeframes that they're updating the information? And how are you using the data when it comes back in? You can look at your sold deals versus your advertised prices. You can look at the stock numbers. You can look at those things. But there are things that you can do today that will allow for you to start to analyze and self-audit the things that you don't like as a dealer principal or a general manager from the staff. Go look at your resources and determine, does everything align? It's not hard to check. Here's my price in my inventory. Here's my price on my website. Here's my price on a third-party provider. Here's the last lead I got, and here's the last deal I marked sold. Is the price all the same? If it's not, gotcha.
Mm-hmm. Gil, do you have anything to add?
I agree with Jim and Greg. I would also think that it might be a good idea to update your policy manual, playbook, whatever you call it, where you're outlining what the expectations are of the managers in this area so that you've got it in writing and you're giving them the tools that they need to be successful.
Yeah, thanks for bringing that up, Gil, because everything starts with a written policy. Just that is the foundation stone of a meaningful compliance program. Put it in writing. We talk about, to Greg's point, you have to expect what you inspect, but you also have to define what you expect. And that's your policy document. And, we're creating a advertising policy document here at Mosaic. We weren't going to promulgate it until after today because we wanted to hear what the FTC had to say. And then they said nothing. So we'll publish our best guess, but it's going to be that. It's going to be an informed guess because we didn't get anything from the mouth of the bull.
Tony D with an awesome comment, and stop allowing salespeople to post payments and prices of cars on their own personal social media.
That has to be in the policy. That just exactly has to be.
Has to be defined. I know everybody wants to channel the social media channel for sales, and it's hot, and we're all seeing certain players in the industry that have done really well creating huge followings behind social media accounts. But now more than ever, that is such a risk vector for dealers. I mean, with pricing changing so rapidly, those social posts being consumed days after the fact, customers coming in, seeing the advertised price, and now we're a week later and that car sat on the lot for an extra week and that price has changed. I imagine you guys have some concerns with that.
Well, and early on, I think Jim Dietrich talked about phone calls coming into the BDC perhaps, and quoting prices. How do you monitor that? Well, some of those calls are being recorded. So there's the opportunity for the dark side to, go and get those recordings, subpoena the recordings, and see what we're quoting folks. And if it's not the correct price, there could be a liability there.
To everyone that's still in the audience, we still have a lot of people listening. If you have questions, feel free to post them. We had a question early on. I don't know if we sufficiently answered it, but I know it's the number one question that's continuing to come up, and it's, so wait, do they mean doc fee? I have to include the doc fee in my advertised price. It's going to continue to come up. So any final words on that?
Yes, this is what it's all about. You have to include, if you charge a doc fee, it has to be in your advertised price. Full stop. That one thing we have no ambiguity about. But think about it. If you have something called a doc fee that you cannot add in on the buyer's order or installment sale contract at the end of the transaction, and it has to be in the advertised price, why would you call it a doc fee? Why would you have it on the installment sale contract? Because if it's already in the top number, essentially you're zeroing it out. I don't even really practically, this sounds to me like it's going to be the death of doc fee or dealer fee under those terms, and it's simply going to migrate to an enhanced dealer pack. And that winds up in the advertised price. And I think you're going to see dealers advertising no doc fee, no dealer fee. And if they were truthful, they'd have an asterisk and say, take a look at our pack.
But whenever there's regulation, and we see this all the time being in the industry whenever there's new regulation, there's always opportunity for first moving dealers to take advantage of that from a sales standpoint. If you come into compliance, and this is something that's getting a lot of press. I'm sure everyone on this call and panel has noticed that these FTC letters to the 97 dealer groups have made their way into all of media, not just our little niche in automotive media, but I've seen it's running CNN, it's running Fox News, like everyone knows about this. So there's always opportunity there.
Mm-hmm.
And the pack adjustment affects the sales staff, right? The people selling the car, because if you lessen the commissionable gross by adding it into the pack, then your sales staff is going to be paid differently. And so there's a lot of moving parts from a leadership perspective of how you go through. Doc fee in some states is, $1,200. In some, I've seen it $300, right? I've seen it all over the board. So when that starts going into pack, but having those questions, right? And I think that the other thing that I took away from Helen's statements were clear consent, right? The consumer acknowledging when additional items beyond the sales price are added to the vehicle. So you agree to the selling price and you add XYZ. Clear consent from the consumer that those ads are added.
Another good question here on something we haven't really touched a ton on in this conversation, but Steve asks, on a first pencil, can you side by side show the advertised price and a second option to add theft, etc., showing both options with advertised price?
As soon as you do that, you're playing defense. Okay, now you've got to explain why it should be legal. I'm not here to say that you can't do that. I am here to suggest that it is not necessarily a safe approach. In my perfect world, first pencil is cost of this vehicle only. Wouldn't calculate any trade allowance. You probably don't know that yet. Wouldn't presume top tier credit score, for a lower. I would have a consistent process where what the first pencil will be the advertised price at a representative term and APR until you know the customer's actual credit score. And anything that you add to that is on a subsequent pencil. I'm much more comfortable. I think it is much more defensible to leave product out of the negotiations until you're in the F&I box and you have a menu in front of them. That's the most defensible. I'm going to yield to Gil, who's looked at more of these deal jackets than I ever will. Is that the best practice, Gil?
You can't be violating a potential advertising issue if you don't have it on that first pencil, number one. It's like you can't be packing payments if you don't quote payments. So there's, a lot of dealers that still just do a cash pencil or an out the door pencil that don't include products. There are others that'll do it on the second pencil, but we highly encourage that they use the word optional next to theft or optional gap. Because let's face it, there's going to be times when the consumer comes in and says, I had a service contract and a gap on the last car I bought from I want one on this SUV as well. And you're going to do what the consumer wants, or else you're going to blow them out. But as a standard practice, I would leave anything off of that first pencil and then start attacking it on the second pencil.
We have some dealers that have approached this. Earlier, I was asked, what does a best practice look like? We do have a few dealers that their very first pencil is purchase price.
Mm-hmm.
And then the consumer says, I'm not writing you a check. I need to finance this. Great. Now we'll go to credit. You'll give me permissionable purpose for that. And then they will add the trade. Then if there's rebates, it's, that's all on the first one. Then they'll add the trade. and then they'll do additional products if the consumer wishes to. But each step of the way, they have the consumer acknowledge. So they've taken their desking to a 3-pencil process. First process, straight purchase price. Customer acknowledges that they're not a cash buyer, they're going to finance, then they've got a trade. Now I work a deal with the trade, then I look at add-on products. So they do it from a 3-phased approach.
Yeah, that's great. Greg, anything else you want to add to what the ideal dealer looks like? Because I know we talked about that earlier.
Well, I think that the ideal dealer is right now. I think that a lot of dealers that are on here are saying, I don't even know when my inventory is syndicated. So find out who is syndicating your inventory and sharing your prices online, and find out the frequency and the schedule with which it's done, so that you understand when edits and changes are done and where does it go and what is the frequency. But a lot of people don't even know. And then when your website provider, which is where both of these infractions, I think, started at, because they were both samples of their websites. How is that data displayed on your website? Is it clear and concise? Is it unconspicuous? And is it clearly detailed of what the total selling price of the vehicle is? And if you can't answer that, then start on those two. And that is what a lot of our dealers have started doing, is where does the website come in? Because you have a lot of phone calls that you're going to have to make, right? You got your inventory provider, you've got new and used, you've got your pricing, you've got your syndication, you've got website provider, and you've got others. If you don't have an end-to-end solution that's controlling all of that, then you have to get the rules of engagement of each one of those vendors and find out what your options are and how you can change the way that your data is used.
Great. Tom asks, we focused on total sales price, but leasing is advertised as payments. Any insight on how the doc fee impacts leasing?
Hi, Tom. Thanks for joining us today. I haven't looked at your lease ads, but if it includes a gross cap cost as part of the ad, then I would think that gross cap cost would have to be similar to what we're talking about, the advertised price on a retail.
Boy, I mean, but his
The good
point
news
is well
is,
taken.
the good news is that the dark side doesn't really attack leasing just yet.
It's hard to attack leasing because nobody buys or nobody leases, because they're not buying. Nobody leases based on gross capitalized cost. They don't even know what it is. I would say that, and this is just me talking, I would say that if you advertise a payment, you must be able to get that payment. And the other things, assumes $40,000 due at lease signing or delivery. I mean, that's clearly nuts. But how often, Gil, you're the auditor, how often do you see fraudulently stated lease payments or ridiculous terms to support it? Because usually it's the OEM, is it not, that comes up with a lease ad?
Well, many times it is. And again, we haven't been reviewing the ads to see, the test of the accuracy of the ads or not. But the first pencils on leases, there's a number of ways that you can manipulate a payment in leasing, and that's why you should never disclose the money factor to begin with, because there's no disclosure requirement. But you can goose the residual, you can goose the money factor, you can goose the mileage, you can goose the term. But when I do the calculations based on those variables, the payment that's being quoted by and far and wide are accurate according to those variables.
Great. So Gil, Caroline Ross, I think, is asking for clarification on what you were talking about earlier with first and second pencils. So VIN Solutions showing first pencil as advertised price, including doc fee, plus tax, title, and license, and the house rate. And then on the second pencil, optional paint and fab. Sound okay?
Yeah, Caroline is asking for clarification on my earlier comment that first pencil shouldn't have products. and then go to the second pencil. And Caroline, we'll talk about it later, but I would certainly recommend and will recommend that second pencil with paint and fab show that it's optional.
Mhm.
That way, because one thing I think that the FTC is focused on are required products that it's already tint's already installed on the vehicle, so therefore it's a required purchase. So that price of tint needs to be in the ad. If it's an optional paint and fab and hasn't been applied yet, then you can go ahead and put that on the second pencil as optional.
I have a follow-up question. Oh, and another question coming. I have a follow-up question from Stephen. Stephen, I'm not sure I 100% understand your question. I'm going to put it to the group to see if smarter minds than mine do. He followed up on the side-by-side advertised, or the side-by-side first pencil where we have an advertised price and then we have a second option to add theft. So kind of similar to the previous question. But he followed up with e-contracting. We do not have a way through our DMS system when e-contracting to show the entire document. You have to scroll to sign. Is the FTC saying we need to go back to paper contracts?
I didn't hear anything implicitly.
Yeah, I didn't hear anything
the signing process.
Okay, Stephen, if you want to add any additional context there, feel free to.
Well, with the e-contracting as well, the customer is supposed to initial at the bottom of each page. So that, that would take care of any disclosures within that one page.
Mm-hmm.
And then, Tom is back with us. Tom, thanks for the compliment. He's talking about dock fees on a lease, and then it's included in the gross itemization of gross cap cost. That's why, Tom, I said that if the gross cap cost, not the agreed upon price of the vehicle, but the gross cap cost would be what I would look at to look for compliance, because that would include the dock fee. You're right.
And Stephen did add a little additional clarity, saying his previous comment was regarding the requirement for the full document to be in view when signing.
I think Gil addressed that well with his respective. If you've got an e-signing, e-contracting solution, and it requires you to initial or acknowledge every screen, one screen at a time, I think that actually does a better job of bringing your attention to a limited amount of the contract at a time than the whole document, the whole paper document would. So I will say that was not on my bingo card.
Keep the bingo card down, Jim.
Bingo card is down.
Hey, put that down.
It's how I kept track of the issues that were addressed. And it just sort of suggested itself, Jim, make a bingo card. And I did get 5 in a row across the top.
I want to say thank you to our esteemed panelists. You guys have helped have a really, really good conversation today. I think it's been beneficial for everyone. Before we go, if anyone has additional questions, how can they reach you all? There we go. Right on cue.
Screen cap.
Screen cap that. Again, everyone who registered for or attended this webinar is going to receive a follow-up email with the recording of the webinar, and we'll try to throw in everyone's contact information as well in case you weren't able to get it on this screen. Again, I'm Tyler Raquette from Mosaic. Thank you all very much for attending. We hope you learned something, and reach out with any other questions that you may have.